So it is my job today to get us started. I send to you all the sincerest regrets of Dean Stephen Mazza, who was called away on important deaning business. But not only his sincerest regrets to not be able to be here and welcome you into our space, but also his sincerest pleasure at the really exciting day and the really exciting edition of the Journal of Law and Public Policy that will come out of what we know will be really rich conversations today. I also stand before you. I'm always a little bit performative, let's just be honest. But I stand before you particularly performative today. About 18 months ago, I gave the keynote address at a conference in New York City where we are talking about, you know, for lack of a better way to describe it, work. The meaning of work and the future of work in this country. And I was wearing this outfit. It's like my traveling work outfit. Like you can do a lot of stuff. It's very functional. Someone ran up to me afterwards and said, "It was so great that you came and you talked about work dressed as Rosie the Riveter." And I said, I guess this does channel Rosie the Riveter. And I was super excited because I would do that even though I hadn't done that. And so today, again, as we continue national level conversations about the future of work, close to my home this time, I channeled my best Rosie the Riveter. And I want you guys to just really think. I'm channeling her so you can see it. You don't need to pull up on your phone Norman Rockwell's famous cover of the Saturday Evening Post, May 29th, 1943, that has become and remains one of our cultural icons, American cultural icons, international cultural icons from World War II. But I want you to stop and really think about why that's a cultural icon and what that augured for us. And what that augured for us was really a conversation, a set of questions, and a path in which the nature of work changed forever, right? In the post-Rosie the Riveter America, not just marginalized community women, like black women who were always a part of labor, became a part of the labor force more generally, right? Women entered labor regardless of class. The labor force became increasingly integrated, right? The nature of work, what we were doing, who we were doing things for, the scope of labor and work, and the markets in which we were in play changed forever. And we don't necessarily have a Rosie the Riveter image that I can think of for today, but we are really meaningfully in a similar moment in time. Culturally, politically, and technologically, we are in upheaval. And among the most important questions we have is what will and what should work look like. It is so exciting then that Abby Lee, our Symposium editor, decided to have this conversation and decided to bring this conversation to the University of Kansas and then share it broadly. We have been really fortunate here at the University of Kansas that our journal this year, and I said this, has been lowercase entrepreneurial in thinking of how to really enrich and engage conversations in ways that matter, from launching an online space to really being creative in thinking about just who was going to be in the room to have the conversation today. And so I thank not just Abby Lee, our Symposium editor, but Denise Dantzler, who is this year's editor-in-chief of the Law Journal, and all of the members of the Journal Board, and all of the KU Law students, right, the 2Ls who make the day-to-day work happen, for realizing that this was an intellectual space that they wanted to be a part of, and they've created a great event for us. I also want to thank all of you for joining us and recognizing how important this conversation is, and recognizing that it is a multi and interdisciplinary conversation, and that it is among the most critical questions that we will face, I don't know, for the foreseeable future. You're going to tell us, right? I'm not going to mention any names at this point because we'll hear them as the day goes on. But I also want to take just a second to call out a couple of KU faculty members. Joyce Rosenberg, who is teaching at the moment, Kyle Velty, who really supported the journal in thinking through which voices and in which spaces make sense to have in the room. I also want to thank my co-advisor of the Journal of Law and Public Policy. This is my first year working with him, and he's really been an institutional stronghold, right? He's the institutional memory that allows and creates space for the amazing students that we have working here to do the work that they do. And I want to finally thank our co-sponsor of the symposium, the Shokardi and Bacon Center for Excellence in Advocacy, which is housed here at KU Law, and it serves as an umbrella for a number of our advocacy courses and our programming to develop our students' interests and skills in litigation, advocacy, and thinking broadly about the kind of work lawyers do and the kind of things the students who participate in the Journal of Law and Public Policy realize are so important. That's all I got for you today. You won't hear anything else from me, but if you can join me in welcoming Denise Dantzler, our editor-in-chief, to really get the day started.
Good morning, everybody. Welcome to the 2020 Kansas Journal of Law and Public Policy. My name is Denise Dantzler, and I'm the editor-in-chief. Just to reiterate Professor Buell's thanks for all of you coming here. I would also like to thank Abby Lee for all of her hard work and her diligence in getting this symposium together for us. Also, I would like to thank the Shokardi Bacon Center for sponsoring us today. So for those of you who aren't familiar with our publication, the Kansas Journal of Law and Public Policy was created in 1990. It explores and examines how public policy choices shape the law and how the law shapes public policy. The journal advances contemporary discourse on judicial decisions, legislation, and other legal and social issues. With its 3 published issues per year, the journal promotes analytical and provocative articles written by students, professors, lawyers, and public officials. The journal endeavors to enable the public policy making process through the presentation of critical analysis like today, Future of Work. Today's symposium, as Professor Buell explained, we will delve into the changes of the work environment and how those have impacted the legal community, and we will explore public policy solutions to those issues. I hope you enjoy and engage in the intellectual conversations today. Thank you again for joining us, and with this, I turn it to Jared.
It is my pleasure to introduce this morning Professor Ngozi Okidegbe. Professor Okidegbe holds the Harold A. Stevens Visiting Assistant Professorship at Cardozo Law School. She is a graduate of McGill University's Faculty of Law and Columbia Law School. She formerly served as a judicial clerk at the Constitutional Court of South Africa and at the Court of Appeal for Ontario. Her research explores how race and ideas about race impact procedural and evidentiary outcomes in the criminal justice system. She has published on topics of race, technology, and human rights. Her most recent work explores the increased utilization of algorithmic tools in the criminal justice system and how these tools affect racially marginalized communities and the practice of law.
Good morning. Thank you for that wonderful introduction. And I'd like to thank the editors of the Kansas Journal of Law and Public Policy for inviting me here today to speak at this timely symposium about work and the way in which new technologies are affecting work. And I think that this symposium really has situated itself in a broader conversation about the ways in which new technologies are shaping and reorienting social legal processes and structures. And it is my pleasure to discuss this phenomenon as it relates to race, algorithms, and the practice of criminal law. Algorithms are transforming the daily practice of criminal law. They use statistical methods and big data to predict outcomes at every level of the criminal justice system. Police are using algorithms to intercept individuals that have been flagged as at high risk of committing a crime. Pre-trial algorithms that are designed to predict the statistical risk of a defendant's risk of flight or pre-trial crime are being utilized by bail judges to inform the decision to release or detain a defendant before trial. Sentencing algorithms that purport to predict an offender's risk of recidivism are being utilized to inform the decision of how long an offender should be sentenced for, or even if an offender is eligible for a non-custodial sentence. And parole boards are also using algorithms to determine whether or not to release an inmate for parole. So algorithms are everywhere. And these algorithms have a significant comport on the daily lives of all, but particularly the lives of those who have been ascribed racially marginalized identities and live in low-income communities and have frequent contact with the criminal justice system. These algorithms inform the decision of whether to apprehend or detain a person before trial, a decision to which has familial, communal, and individual consequences, particularly when this person is from a marginalized community. And most states are either using or considering using algorithms at some level of the criminal justice system. Their use is part of a broader socio-political movement to reform a broken criminal justice system. On both sides of the aisle, most people agree that the criminal justice system incarcerates too many people who could otherwise be released without posing a threat to community safety. And so, political actors have turned to algorithms as some sort of solution to this growing crisis. The claim is that these algorithms provide objective, evidence-based assessments of an individual's statistical risk, and that their increased usage will improve the criminal justice system by conditioning a person's interaction with police, a person's apprehension, or a person's detention on statistical risk rather than the subjective whim of a police officer, a bail judge, or some other criminal justice actor. Today, we're in a fraught debate in criminal justice reform circles about the use of algorithms. And the debate is like this. Proponents of algorithms contend that this technology will enable us to reduce high rates of incarceration. But research scholars contend that the increased use of algorithms actually threatens to entrench racial inequities, and at worst, exacerbating them under the guise of scientific objectivity. And so, in this talk, I'm going to discuss the urgent and difficult challenge that the continued use of algorithms pose to the pursuit of racial justice in the criminal justice system. I will then look at the various options available and advocate for a two-pronged approach. So, to begin, algorithms pose a tough challenge for racial justice. The first reason has to do with the inputs of these algorithms. Even though these algorithms do not utilize race explicitly or racial information, they still utilize factors that correlate with race and historic racial inequities. For instance, pretrial algorithms take into account an individual's rate of arrest or arrest record. Okay? But arrests are not racially neutral. We know that members of historically marginalized communities are arrested more often for similar rates of offending than their white counterparts. This means that the growing use of algorithms that utilize factors such as arrests end up entrenching the racial disparity in the system. And furthermore, as Sandra Mason's work has shown, algorithms are based on the premise that the past will replicate itself into the future. These algorithms rely on past data. That means that if the past is racially disparate, which we know it is, if past police practice, if past court decisions are racially disparate, then the algorithmic systems that decide these issues will also produce racially disparate outcomes. And so because of this, the greater use of algorithms has not resulted in the reduction of racial disparities. In any of the jurisdictions that we can look at that have implemented algorithms, racial disparities have largely stayed the same. And so this is one reason for which algorithms threaten to maintain rather than root out racial inequity in the criminal justice system. The second problem with these algorithms is that they maintain the socio-political condition that produces risk of crime and its management with incarceration. An individual's risk of crime is often the product of systemic but often changeable factors. For instance, a robust social assistance program could reduce an individual's crime risk. Having court reminders could make it so a defendant would be more likely to show up for a bail hearing or some other court event. However, when we rely on algorithmic systems in isolation, we allow ourselves to ignore the socio-political context of crime. And this allows society to exculpate itself from our responsibility in creating and maintaining the conditions that give rise to risk. It allows us to pretend that crime risk is solely the result of an individual's choices, behavior, or characteristics instead of societally constituted. Not only does this maintain the status quo, it means that it fuels racial tropes because algorithmic predictions ignore the realities of race-based structural disadvantage. This allows society to view over-incarceration of Black people and Latinx people as natural instead of socially constructed. This state of affairs perversely facilitates the continuations of racial inequities rather than deals with dismantling them. And the third problem that these algorithms pose to racial justice has to do with the fact that these algorithms do not consider the individual familial or communal costs associated with an individual's incarceration or apprehension. In low-income communities of color, increased police contact, increased police apprehension, and increased rates of over-incarceration have ravaged social kinship networks. In some neighborhoods, the sheer number of Black and brown people entering and exiting the criminal justice system has created a gendered, racial, classist geography of poverty and political disenfranchisement. And the algorithms in use do not consider this harm and its magnitude. These algorithms disregard the private and social costs associated with apprehending a person or detaining them before trial. They ignore the fact that there are mitigating factors. And in some ways, this is worse than the system that these algorithms seek to replace. Traditionally, criminal justice actors have had discretion as to who to apprehend and who to detain. And though this discretion was often exercised in racially disparate ways, Sometimes it resulted in leniency. It depended on who is the decision maker, and it still depends on who is the decision maker. However, algorithms cannot show leniency. They do not consider mitigating factors. This omission uniquely harms members of low-income communities of color who live at the intersection of political, economic, and social disadvantage. Remember that a person's detention could mean the loss of their employment or the economic disenfranchisement of their entire family unit if they're from a low-income community and particularly from a low-income community of color. For this reason, it is difficult to imagine that the greater use of algorithms will decrease the negative externalities of incarceration and mass surveillance on these communities. Instead, it will likely worsen it. And the final problem that these algorithms pose from a racial justice perspective is that they are privately developed and owned. The developers who create these algorithms tend not to seek input from the people who are the most impacted by them. And the explanation that's often given for this lack of community consultation is that these communities lack the technical expertise to provide meaningful input about the design of these algorithms. However, as Jessica Eagle's work has demonstrated, algorithmic construction is only partly technical. It mostly involves significant normative assessments about the factors that should be used and the weights that should be assigned to the factors used. So this means that people from most impacted communities could be contributing or influencing these algorithms but are currently not being utilized to do so. This has resulted in members from these communities being disproportionately impacted by algorithmic predictions that they have no ability to influence. For this reason, the algorithms currently in existence pose a critical threat to racial justice and to the members of low-income communities of color. It is therefore vital for racial justice scholars to creatively think through all the strategies available to address this crisis. Now, one view that's been put forward by those outside of racial justice circles is that these algorithms should remain in existence. They're better than what we currently have, is the argument. And in support of that view, these scholars point out that criminal justice actors themselves have tended to make arbitrary, ill-informed, and often racially biased decisions that have culminated in the current crisis of mass surveillance and mass incarceration that is racialized and that we live with today. And to this point, it's true that racial inequities are endemic in the criminal justice system with or without algorithms. However, these algorithms have the same racist pathologies that criminal justice actors can suffer from. But they're worse because they're able to produce these same racial inequities as criminal justice actors, except the production is under the guise of scientific neutrality. This state of affairs makes it harder to contest the racism endemic in algorithmic systems and perversely allows algorithms to legitimate existing racial inequities. So for this reason, the algorithms in use should be resisted. Their use will only contribute to maintaining racial stratification in the criminal justice system. However, I fear that mere resistance will not lead to the dismantlement of these algorithms. And the reason is that political actors are turning to algorithms as part of a socio-technical phenomenon to use inexpensive technological shortcuts to solve complex societal problems. Algorithms are everywhere, from banking to healthcare, from hiring to surveillance. Algorithms are likely to continue proliferating. And therefore, racial justice scholars are left with this question. What should we do? What should be our response? And I argue that we need to have a two-pronged response. The first prong is to contest and resist the algorithms currently in existence by seeking their dismantlement in criminal justice and beyond. But as long as they remain a facet of the criminal justice system, we must also consider how to influence them and subvert them in order to blunt their racial effects and incorporate them into anti-racist projects to the extent possible. And one way to accomplish this feat would be to strategically situate members from most impacted communities who have traditionally been the object of algorithmic governance and these algorithms into their designers, implementers, and overseers. And to flesh out this proposal, I'm going to spend the rest of my talk on two further issues. The first is, why is it desirable from a racial justice perspective to simultaneously resist these algorithms and also design, implement, and oversee them? And second, how might we be able to secure this result? To the first question, which is, why should we invest the time and resources developing algorithms when currently existing algorithms are entrenching or in some case exacerbating racial inequity in the criminal justice system? Well, first, algorithms are not predisposed to promoting racial inequity. Their effect is a result of their design. Currently employed algorithms are designed to reproduce racial inequities because of the factors that they take into account. For example, arrests. Currently employed algorithms could be redesigned to not reproduce the status quo. And such a result could happen if those designing the algorithms had experience with the criminal justice system and its effect on communities of color, such as if members from these communities were among the designers and implementers of these algorithms. Second, algorithmic-based reforms, unfortunately, are politically popular and inexpensive, which increases the likelihood that they're going to continue to be used. Given this, mere resistance does not end algorithmic governance, but it does perversely prevent those who are most impacted by their usage from influencing them and shaping them. Despite the fact that these algorithms, remember, operate to maintain the mass surveillance and mass incarceration of these communities. It is therefore vital to utilize all options on the table. Also, there is a racial justice reason to consider this option. One way to think about racial justice is outcome-based, but another way to think about racial justice concerns power. Under this notion of racial justice, the goal is to reallocate power to members of racially marginalized communities so that they can direct their communities and hold political actors accountable. As Dorothy Roberts' work has shown, over-incarceration has disempowered members of low-income communities of color by stripping them of the material resources and social kinship networks and other resources to fully exercise political, social, and economic citizenship in this country. To compound the issue, members from these communities are unable to change the operation of the criminal justice system to prevent the over-incarceration of their community members. Due to the operation of felony disenfranchisement laws, as well as the political ostracization effect of the criminal justice apparatus, members from these communities have diminished power to elect judges, prosecutors, and police chiefs. And this means that criminal justice actors tend not to be accountable to these communities. However, if members from most impacted communities were among the designers, implementers, and overseers of the algorithms in the criminal justice context, then their input would be incorporated into these algorithms. And because of how fundamental these algorithms have become in the criminal law process and in criminal law policy, assisting in the design of these algorithms means that this group could participate in directing the criminal law process. It could result in a level of democratization of criminal justice for racially marginalized people that can endow this group with a certain level of power to determine how the criminal justice system operates in their neighborhoods. It could allow them to influence the principles and goals of the entire criminal law system. This idea, if actualized, could lead to a radical reorientation of the system with input from these communities. And I want to conclude my talk by briefly discussing how we do this. There are a number of institutional design choices that could allow for members of most impacted communities to become the designers, implementers, and overseers of algorithms used in the system. My work has engaged with the idea of criminal justice commissions in each jurisdiction composed of members from these communities. These commissions would be responsible for designing the formula behind the algorithm and any algorithm used in a criminal justice context. And an important component of these algorithms could be that they have a communal harm component which actually would consider and account for the communal harm associated with apprehending or incarcerating a person who's subject to an algorithmic assessment. And so there's many institutional design choices that could be employed to do this. I've also explored the need to think about having technocrats on the commission as well in order to have a blending of communal and technocratic expertise. And the ways in which we can think about institutional design choices to ensure that power is maintained primarily in the hands of community commissioners. And the point of this is to say that there are many ways to imagine ensuring that members from these communities can actually be part of the process of creating these algorithms. And it's important to note the limitation of my proposal. My proposal does not guarantee the end of mass surveillance and over-incarceration. That could only be guaranteed if we would move towards complete decarceration or abolition of the criminal justice apparatus, as many racial justice scholars have advocated for. However, until either of those options are achieved, the proliferation of algorithms demands creative thinking about how best to blunt their racial effects. An approach that only critiques algorithms without a consideration of what we should do with them or could do with them in anti-racist projects is becoming increasingly unsustainable and unadvisable. When viewed in the present-day context, the approach fails to offer a way forward if opposition to algorithms is unsuccessful. The hope of this talk and my work is to start a conversation about the need for a multifaceted approach to addressing the dangers posed by algorithms to communities of color. And racial justice demands the resistance to attempts by the establishment to inscribe racial hierarchy by algorithm. But it also demands seizing opportunities to subvert the technology for anti-racist aims where possible. And though my talk has focused on criminal justice, my approach has far-reaching implications for how algorithmic-based strategies could be used to fight and disrupt practices, laws, and policies linked to racial stratification in other areas of the law as opposed to maintain them. It's important that we reckon with what's at stake with the coming algorithmic governance and carefully evaluate the options. I've enjoyed speaking with you all today, and I'm excited to engage with you in the question and answer period. Thank you for listening.
So with that, we're going to open the floor up to questions for Professor Okidegbe. Please feel free to raise your hand. You should be happy to take the questions. I have a question. I'm happy to ask questions. You talked about certain metrics that are not helpful and contribute to racial stratification. Do you have proposals for certain metrics that would be helpful to still accomplish maybe the end goal of community safety but minimize the risk of racial stratification?
Okay, and that's a really good point. I think it's important that we think about the question of community safety broadly. Often we think about community safety in a very narrow way. And the idea is that, okay, an individual has a really large arrest record, and the idea that that person might be dangerous, we might want to detain them before trial. However, the actual detaining of an individual before trial could have externalities on the family and other parts of the community. So for instance, you have a situation where a person is the primary caregiver of a child. The result of that person's incarceration means that that child might have to go to foster care. It could also have ripple-running effects, and that actually also affects community safety. And what happens when that person is released? Maybe because of the fact that the charges are dismissed or they're found to be innocent. We also know that the criminal justice system unfortunately inflicts trauma on a lot of people who are in incarceration. So now that person might be more dangerous. So we have to have a broader notion of what community safety means. And if you have a broader notion of community safety means, something like a person is the primary caregiver of a child would lead to that person being less likely to be incarcerated and more likely to be incarcerated because you can see the communal harm that would be associated with their incarceration. So I think that having people who are from these communities would actually allow us to really pinpoint what factors are actually going to go against community safety and what factors are going to go for community safety.
So I have a comment and a question, probably. So I liked what turned my brain synapses firing. As you described, the sort of policy idea that the very folks who use the language ascribed racially marginalized identities should be the designers, implementers, and we said overseers of these algorithms. And what my brain started flashing, right, is a very powerful historical image of the overseer in chattel slavery America, where the overseer was precisely the individual ascribed the racially, or could be the individual ascribed the racially marginalized identity, but was tasked with implementing these, draconian, dehumanizing policies. And so so that language led me to really start thinking, who are how do we find this likely community of folks, if you talk about the community commissions, who are going to be not co-opted for the precise harms that you talk about as the potential in algorithms, and why this is a project that also involves resistance. The comment, so that was the question, like how do we do that, and what is the sort of vigilance that is required? The comment is, I just think this is really great, and there are a couple of places where I would love to see you engage. Ruha Benjamin, who is at Princeton, has this language about the opposite problem, in the sense of we realize our algorithms are racist, and so we want to test them on people because we want to de-racist them. And so we're going to the very marginalized communities, and we don't have like a system of calling this work and compensation. So I would love you to engage with that. And then you talk about institutional design. And Neil Commissar, who is at Wisconsin, just does this great work on institutional choice. And I think that would just really enrich my understanding of, again, the process of choosing the commission and how we do that.
Thank you for all of that. That was great. To your first point about the question of co-optation and the concern about how we figure out the community, I really think it's important to start from the perspective that this is not the ideal choice. The ideal choice is not to just continue algorithmic governance and have members from communities most impacted be among those designing and implementing them. That is a second choice. The better option would be to dismantle the criminal justice system and the racial disadvantage that it imposes on these communities. That would be ideal. So I think that's really important. The second question about co-optation is a very difficult one to grapple with, and you're right about that. And I think, and the way that I've tried to engage with this question in my work has to do with this difference between outcome versus power. Because I think that if you think about it in terms of outcome, there is just no way that my proposal can guarantee that we would address over incarceration and mass surveillance. Because even no matter how we tailor who's the community and who can be a commissioner on the community, there's so many ways in which power dynamics within communities can result in certain people's voices being muted. If you have an appointment process or if you have a democratic process. So instead of talking about outcome, I think about it in terms of power for that reason, and the idea of who decides. Because that gets us closer to a notion of using these algorithms in a way that is not as bad as they're currently being utilized. So I think that's important. In terms of figuring out who the community is, the way that I've thought about it is it can be considered on a micro level or a macro level. I think on a micro level, we can say to ourselves, okay, well, if we look at a place like New York, where I'm from, there's actually data on the specific zip codes that are most incarcerated. You could say members from those communities would be eligible. But you could also imagine on a macro level the fact that all people who are ascribed racially marginalized identities are impacted by incarceration, even if they don't live in those zip codes. And so it has to be a real difficult policy question about which commissioners would be best suited for this. And the reason I'm interested in the idea of using criminal justice commissions, going to your second question, and I love Ruha Veterans work, she's brilliant on this, is because I do not like the idea of how generally community input is discussed. The idea of, oh yes, we'll have these town halls and marginalized groups can come in and say what they think, and we'll disregard most of their input, and we'll put in this one little thing, and then we'll say it's community supported, which is what happened in Pennsylvania. The reason why I think it's important to have criminal justice commissions is I'm thinking of things like the sentencing commission, right? The idea of actually compensating people and having positions for these people to actually be doing this real work of engaging with algorithmic governance. And I think it's important that when we talk about this question of community input, we're really actually saying, recognizing that these communities are actually naming and trying to redress racial harms. That is work that should be compensated, and so that's the way I see the notion of institutional structure as a criminal justice commission to allow for these community members to actually be paid and compensated for their work. And to your last point, I think you're right about it's not just institutional design, it's also institutional design choices. I kind of narrowed my remarks just for time reasons, but you're completely right about that. I think about the idea of that, and I also think about Raheem's work, who's at Brooklyn Law, who actually deals with the ways in which you have to design the actual institution and the choices that you should make in order to try to deal with the power differentials that can exist in a commission that I'm suggesting, which would include community members as well as technocrats. So thank you so much for all your comments, they're amazing. And I also think that it's really important to think through that and to reckon with the fact that this proposal, again, is not what is the ideal and how we work within that.
Thank you for your remarks. It's super important work, very interesting. So I understand your proposal around trying to change and make a better algorithm. In the meantime, while we're trying to actualize that plan, which I think has challenges, as you've already started to talk about, are there ways to challenge, legal challenges to existing algorithms? I don't do criminal law at all. It's not my wheelhouse, but I do employment law. And I think, if there are employers who are using algorithms that have disparate impact, that you maybe have a Title VII disparate impact claim about use of those particular algorithms. So while we're working on making the perfect algorithm, can we challenge the existing ones that are flawed, and criminal justice system, what might those things look like?
So this is a really great question that you're asking for two different reasons. Many reasons, but I'm going to focus on two. The first is that a lot of the algorithms that we're talking about that are being used are actually privately developed and owned. That means that it's hard to actually figure out what all the factors are, as well as what the weight assigned to those factors are. And this has been a problem because there was a case in 2016 in Wisconsin called Loomis, where an offender who had been sentenced, part of what had informed the sentence was a risk assessment by a privately developed algorithm. And the Wisconsin Supreme Court said that this defendant actually didn't have the right to access the inner workings of it to see if it was actually disparate as it related to gender.
Wow.
Partly because of the operation of trade secret privilege, and partly because of the fact that the way in which these algorithms operate, there's so many different factors that are considered. If you don't actually have the inner working of the algorithm, you can't necessarily say that this algorithm in and of itself is impermissibly taking into account gender or race, because you don't have that. And the other reason is that all the algorithms that I'm talking about, the output of them, are not supposed to determine in and of themselves whether a person is detained or apprehended, or if they're released on parole. It's only one of many factors that a criminal justice decision maker is required to take into account. So this is actually made it quite difficult to mount legal challenges against their usage.
So to follow on to that, we know that a lot of times people view what comes out of the machine as being correct.
Yeah.
And so seeding our decision making and our good judgment, that's something that boggles, that really is spending a lot of time in my brain. Do you have ideas on how we can, other than a duty to warn and saying, that when we see decisions to our technologies, we're losing really valuable inputs that come into play, and how to kind of say, hey, wait a second, just because it came out doesn't mean it's right. It has so many factors. Do you have any ideas on that? Because that is just filling my brain.
So yeah, that's a really important concern. Danielle Keith-Citron talks about this and has termed it algorithmic bias. The idea that we are predisposed to see the output of any computing technology as just being accurate, even if we might know that it's wrong or have a sense that it's wrong. Compass, which is a very popularly utilized, privately developed and owned algorithm, actually says that it shouldn't be used solely for any decision that's not meant for that. So it has like a duty for warn. But as Danielle Keyes-Citron talks about, that actual, just having that is not enough. That is just so, unfortunately, a psychological problem that we have in how we deal with technologies. And so I think one of the things I think is important, and I try to deal with in my work, is that I don't think we can actually address algorithmic bias. I think training will be very helpful. I think that having, of course, duty of warning is helpful, but instead, since we know that we can't stamp it out, it's actually better to have algorithms that have or at least have community input into them, so that if a criminal justice actor is delegating his or her authority to them, which again, they're not supposed to be doing, at least that delegation has some sort of place in the context of community support, as opposed to just what the developers at a particular private company have decided are should be the factors and the weight of the factors.
I have a question. So there's this algorithmic bias where something that comes out of a machine, we just assume it is perfect. How much of a conversation goes towards these private entities that are working and creating these algorithms? Basically what they're doing is inserting their own implicit and unconscious biases into this.
Yeah.
And so the reality is what we're getting out of the algorithm is a collection of that entity's biases.
Yeah, and you're right, and that's what makes algorithmic bias so problematic. I mean, we're first dealing with past data that we know is racially disparate, but we're also dealing with the fact that developers have had to make choices. So for instance, when it comes to pretrial algorithms, you have 3 risk classifications. You have low risk, medium risk, and high risk. Just figuring out what classification should be high risk, that's a normative choice, and developers are making that without soliciting input from criminal justice scholars or from legislators or people with public policy experience. And in the context of Compass, which is staggering, is that in 2010, they released what the actual rate of flight was when it came to the designations. And it was so interesting because, and they haven't done it since, but in the 2010 information that they released, it was found that using Compass, which is a privately developed algorithm, the rate, if a person was given a high-risk designation, their risk of flight was 17.2%. That means most people who were designated high risk would have actually come to court. How is that in any way considered high risk, right? And so that's just choices, normative choices that Jessica Eklund talks about this, that are made all the time with the construction of algorithmic systems. So it's strange that we can have these algorithms that are clearly just embedded with such normative assessments that can be also racially problematic in other ways, but then at the same time think that community input couldn't actually influence it or should be part of it because community input, people from community don't have the technocratic skills. So really, a lot of normative assessments are going on. So you're right about that. It does make algorithmic bias even more problematic.
I very much enjoyed your talk. I particularly wanted to second your observation. The criminal justice system is not aware of the incredible costs it imposes on certain communities. No question about that. They're catastrophic in many ways. I do want to, however, say a kind word about some algorithms and AI processes. Even in criminal law, although I use other examples too, medical diagnoses and treatments have been vastly improved because of AI procedures. And the benefit there has been that a doctor can't know everything. They can identify symptoms, but they can't know everything. And if doctors, with the help of diagnostic algorithms, can identify diseases, I'm an example of that otherwise nobody had seen before or knew how to diagnose. But even within criminal law, there's an example of a very careful study that was done. It resulted in a publication by Kleinberg and others in a Quarterly Journal of Economics in 2018 about the use of algorithmic bail decisions in New York City, and using the criterion of did the person granted bail commit crimes while out on bail or later. They found that the algorithmic procedure was much better at identifying people who were less likely to commit crimes when out on bail than were the judges. And that doesn't surprise me at all. The previous question lauded human judgment and intuition. However, I think you need look no further than the string of decisions made by various administrations since the Vietnam War at least, and some of the decisions being made by the current administration, and decisions made by a string of academic leaders to realize that human beings don't do such a good job either. They need help. And I think in many ways these algorithmic-based programs can help. They may, I think your point that they ought not necessarily substitute for human judgment, but they can certainly inform it. And if we take that process of improvement into account, which I agree with you entirely, there are better and worse ways to do that. I think I'd like to say, be a little bit kinder to these poor, disembodied algorithmic programs. They can do help for us.
So that's an interesting comment. I think what I think is really important, and I get from your comment, which I agree with, is that it's all about how they're designed. It's just a mathematical model. It really is. And so there's nothing about the mathematical model in and of itself that should entrench racial stratification. And I think that there are many ways you can imagine, and it has been the case that algorithms can be helpful, but it's because of the way that they're designed. I think in the context of the criminal justice system, the problem that you have is that any algorithm that you design, even the proposal that I'm discussing about having those who are most impacted by incarceration be part of the people designing them. One of the issues you have is that the whole premise of the algorithm is that it is based on the idea that there are some people who should be detained before trial, or that there's some people who should be incarcerated, and that there's some sort of intrinsic characteristic that those people have. And it doesn't engage with the sociopolitical question, which is what do we mean by that? It doesn't allow us to actually think about what do we mean by public safety? How is that loaded? How is that, a term that has certain racial, gendered, and class notions in it? And so I think that when we think about algorithms in the criminal justice context, there's a particular concern that they actually can't make the system better because they're premised on the notion that the basic underpinnings of the system are okay, and that it just needs to be more efficient. But I do take your point that definitely, I'm not a person who thinks that algorithms are bad in and of themselves. They're not. They can be designed well. But I do think that there's a particular problem here in the criminal justice context.
Have you had a chance to speak to folks that manage civilian review boards? Because, you think about it, the way you're thinking about wanting to build this independent body of researchers to, test the validity of these models, they may already be receptive to you. I don't know what they use to, civilian review boards. I don't know what they actually do against police activities, but I would imagine they would be happy to hear somebody who said, let's introduce a little more complex, a little more rigor to your process. Because, I know in my hometown, they've started one. And basically what it does, of course, is a way to manage and make sure the cops quote-unquote behaving, so whatever that means, right? And I don't know if they use data right now, but it may be a good audience to not get to the big picture where we want to go as like a stepping stone to get there, to have them invite you in to discuss those things.
No, that's really important. And actually, Andrew Ferguson actually talks, as a scholar, a criminal justice scholar, who talks a lot about policing algorithms. And his work actually deals with how you can create algorithms that would actually identify police officers that might be at most risk of committing misconduct. And so he's working on the idea of kind of flipping the script on who is the object of these algorithms, instead of it being police using these algorithms to identify high-risk people who might commit a crime. It should be used by civilian boards or community groups to actually identify which police officers might be at most risk for conduct. So there's misconduct. So you're right that there is ways in which civilian boards can utilize these algorithms in that way.
That's the same model used for predatory lending, right?
Yeah.
It's like, it's not about persons being denied, it's like who are the groups of folks denying them of these loans?
Yeah.
Which is a different way to look at the data.
Building off of that a little bit, it's such a great idea. Have you reached out yet, or maybe in the next phase you reach out to see if anybody's actually acting on this idea?
So I've looked at it, in what I've looked at so far, this idea hasn't been implemented. There has been situations like, and I briefly noted about this for Pennsylvania, where the sentencing algorithm that they recently adopted, they had these town halls where they had community members who were invited to come, anyone could come, and talk about what they thought about the algorithm. But they basically decided that the community input, which was to say that there is a problem with an algorithm that only incarcerates as opposed to considers mitigating factors as wrong, they didn't take that into account. And so they ended up not really taking into account the community input. So I'm not the first person to say that there should be community input in the design of algorithms, but I'm the first to talk about how we can think about actualizing input in a way that really gets at design and implementation. And so I think there is an interest in for those who are creating algorithms going forward and getting community input, but the problem is how much they actually really want to incorporate it and actually give power to these communities. And I think that's where